Good morning, everyone, and welcome to today's webinar. For those of you who have just logged on, we have already completed a sound test, and thank you very much to everyone who helped out with that. Firstly, I want to introduce ourselves. My name is Jennifer Patton, and I'm the HR consultant for Bright Contracts here at Bright. Joining me today is Saoirse Maloney, who is the HR admin at Bright and an additional point of contact for Bright Contracts. Just to note, this webinar is being recorded and all attendees will receive an email later today with a link to the recording. So it's no problem at all if you do need to leave at any stage. If you do have any questions, you can type them into the questions box on your control panel at the side of the screen, and we will try to get through as many questions as possible at the end of the webinar. Also, in the follow-up email, there will be a copy of the presentation slides that we are using today. So let's get started. So first up on the agenda for today, we will look at probation, where we will discuss everything related to probation, including the benefits, as well as how to manage your employees while on their probationary period. The second topic of the day will be retirement, where we will discuss the facts as well as management of retirement information. At the end of the webinar, we will have a questions and answers section where we will answer any questions that you may have on either topic. So I'll now pass you on to Saoirse, who will get us started on the webinar.
Thank you, Jennifer. So the first topic we will discuss is probation. So firstly, what is probation and what does it mean? Probation refers to the period at the beginning of employment where the employer assesses whether the employee is suitable for a permanent position. Employers can dismiss employees with little or no notice during this period. So how long is the probationary period? There is no mandatory period length. It is at the decision of the organisation. However, the best practice is for it to be between 3 and 12 months, and it should never be longer than 1 year. 3 to 6 months is the general norm length of the probation period. Probation can be extended, however, it cannot run over 12 months. During the probationary period, there are probation review meetings. The manager must have regular meetings with the employee to assess their progress during the probation period. The aim of the meeting is to provide feedback to the employee on how they are progressing. In the final review meeting, the employer will notify the employee whether they have passed or failed the probation period, or their probation may be extended, generally by another 3 months. If an employee has failed their probation, they must be given at least 1 week's notice.
Thank you, Saoirse. So let's look at the benefits of probation. Probation allows employers to determine whether they have the right skill set and the ability for the role, as well as seeing if they have the right fit into the team. It is also possible to dismiss any unsuitable staff members with little or no notice. Now, the age-old question is, can you let someone go during probation? And the simple answer is yes. You can dismiss an employee during their probationary period based on issues related to conduct, attendance, or performance. Now, if probation is mismanaged, the employer may face the risk of an unfair dismissal claim, which is obviously something that we would like to avoid. Whilst an employee is not protected by the Unfair Dismissals Act until they have accrued 1 year's service, claims for unfair dismissal can actually be brought under the Industrial Relations Act. So employers should be aware that although dismissal during probation is possible, it doesn't give employers a right to act as they please. So fair procedures and natural justice should always be respected. Now, an employer cannot dismiss an employee during the probation period due to them being part of a trade union, for pregnancy-related matters, or any entitlements under parental rights or carers leave. So how can employers manage employees on probation? Well, employers should support their employees by following these steps. They should make sure that the employee understands what is expected of them. They should provide training to support and help the employee fulfill their role. And also make sure that managers conduct interim reviews and end of probation review meetings to discuss any progress or to discuss any areas that may need further improvement, just to ensure that the employee is always getting consistent feedback. So now that we have discussed probation, we are now going to move on to retirement. So firstly, what is retirement? Now, retirement refers to the time of life when one chooses to permanently leave the workforce behind. Now, a mandatory retirement age must be included in contracts of employment and handbooks. In October 2021, the Commission on Pensions report was published, and in this report it was recommended that legislation should be introduced to prevent employers from setting a compulsory retirement age below the state payment age, which is currently at the age of 66. The report also suggested that pension age should be increased gradually by 3 months per year from 2028 and reach the age of 67 in 2031. Now, it also suggested that further increases should be implemented every second year after 2031, meaning that the state pension age will eventually reach 68 in 2039. Now, it is important to note that there actually is a statutory retirement age in certain roles. Now, what this means is that it is set out in law. So roles which would follow this statutory retirement age are roles such as members of the Garda Síochána. So they must retire by age 60, but if they joined after 2004, they can actually choose to retire as early as age 55. Then you also have full-time members of the fire service who must retire by the age of 55. Now, next we'll move on to contractual retirement age. Now, under the Employment Equality Act 2015, whilst employers are allowed to have contractual retirement ages, this sets out the provision for an employer to be able to objectively justify the need for the retirement age by a legitimate business aim. So what this means is that employers must have a legitimate reason in operating a retirement age and have evidence that the means of achieving that aim is both appropriate and necessary. So examples of what constitutes a legitimate aim by an employer can include intergenerational fairness, so that's allowing younger workers to progress, motivation and dynamism through the increased prospect of promotion, health and safety, which is generally in more safety critical occupations, and the creation of a balanced age structure in the workforce, as well as professional and personal dignity. So avoiding capability issues with older employees. So for example, you may have an employee who has been sick a lot over the past year and maybe their health isn't where it used to be, and unfortunately they may not be capable to carry out the role that they're doing at present. That would be a legitimate aim. Then the last example would also be in relation to succession planning. So what exactly can the employer do in relation to retirement age in their workplace? Well, they could enact a retirement policy, which Saoirse is going to go through with you all next.
A retirement policy will set out the purpose and aim, as well as specifying the scope of the policy and making reference to any other legislation, policies, or documents which support the interpretation and operation of the policy. Where there is no fixed retirement age, a retirement policy is likely to form part of a suite of policies covering career planning and development, performance management, capability, flexible working, and equal opportunities. The contents of the policy and related procedures must comply with the requirements of the Employment Equality Acts in relation to age discrimination. So what are the key features of a retirement policy? Well, a retirement policy will contain details of any specific arrangements the company has in place to support employees of any age who are either voluntarily considering early retirement or who are to be compulsory retired. These may include, for example, pre-retirement courses, advice on pension options, or general financial advice. Secondly, it will detail flexible working opportunities and procedures for applying for this, such as part-time working, reduced hours, or job sharing, what the company makes that the company makes available to employees of any age, and which may be particular interest to employees seeking to phase into their retirement. Thirdly, it may provide provision for the employee to receive written confirmation of any agreed variation to his or her terms and conditions in the event that they also request a change to their working pattern or hours. This is approved. It details the procedure for making a formal request for retirement, for example, by a letter of resignation or standard form. It also details retirement notice requirements. This would be the minimum notice detailed in the employee's contract. The notice can be extended by a mutual agreement with the employer. It also provides for a meeting to be held to discuss formal retirement requests. Example, to agree leaving dates, initiate pension arrangements, discuss handover arrangements, or training of replacement staff. And lastly, a retirement policy may provide the employee to receive formal written acknowledgement of the resignation request and confirmation of the date of retirement.
Great, thank you, Saoirse. Now, what I'd like to mention in relation to retirement is the Code of Practice on Longer Working, which some of you may be familiar with and some may not. But to talk through it here, what the Code of Practice on Longer Working is it was actually published by the WRC in 2018. Now, it actually isn't legally binding. However, it does hold considerable influence and employers are reminded to act in line with its contents. So to go into the topic briefly, the Code of Practice deals with 4 issues. So you have the utilisation of the skills and experience of older workers, the objective justification of retirement ages, practical retirement arrangements in the workplace, and dealing with requests from employees to work beyond the normal retirement age. Now, to go into each of these sections in depth, first of all, the utilisation of skills and experience of older workers. So here, employers are advised to take certain measures, more particularly set out in the code, that deliver a positive message around valuing a diverse range of employees. So this can include employees of all ages. Now, the code also recommends raising the issue of age discrimination with your staff as well, to ensure that there isn't a culture of discrimination that's going to develop. Now, to go into objective justification of retirement ages, following the enactment of the Equality Act in 2015, compulsory retirement ages set by employers must now by law be capable of being objectively justified, which we have obviously already discussed. But this is obviously due to the existence of a legitimate organisational aim and giving evidence that the means of achieving that aim are both accurate and necessary. Then next, going into practical retirement arrangements in the workplace. So the code instructs employers to manage the retirement path by breaking it down into a process of 3 stages. So firstly, it's recommended that each employee is consulted to identify their individual retirement intentions. Then next, it's recommended that employers provide clear information on how the retirement procedures work at regular intervals in their employees' careers. Now, this applies irrespective of whether the organisation has a pension scheme in place or not. Then the third stage recommends providing the employee with at least 6 to 12 months of consultation on how the retirement process will be commenced and seen through to conclusion. Now, this is such an important step that I think sometimes can be forgotten about in this whole process. So it's just really important to make sure that you're having that consultation with that employee in relation to their retirement plan. And then the final one, it was dealing with requests from employees to work beyond the normal retirement age, which I'll actually discuss in a moment on how to deal with that request. But it is best practice to specify a retirement age in your contracts of employment. So to ensure that a compulsory retirement age forms part of the employee's terms and conditions, but it's also important for the organisation to be consistent in enforcing the retirement age to correspond with the contract. Now, if an organisation does deviate from this contractual condition, it may actually set a precedence for the future. So that's why it's really important that you have your retirement plan, so to speak, and to follow that and carry it through from start to finish. So what exactly are the main provisions of the Code of Practice on Longer Working? Well, employers should provide clear information on how the retirement procedures work. Now, this is both at recruitment and at regular occasions throughout an employee's career. It's not to be forgotten about once an employee starts, so it should always be a conversation at regular occasions throughout every employee's career. Now, employers should also notify the employee of the intention to maybe retire him or her on the contractual retirement date, but within 6 to 12 months of that date. Now, this is to allow for a reasonable time for planning, arranging advice regarding people's succession, etc. Now, while the initial notification should be in writing, it should be followed up with a face-to-face meeting, and this should focus on addressing some of the following points. So there should be a clear understanding of the retirement date and any possible issues arising. It should explore measures which would support the pathway to retirement. So for example, flexible working, looking at alternative roles up to the date of retirement. Any transitional arrangements in regard to the particular post, and any assistance around guidance and information. Now, the next provision is that any request from employees to work longer than their contractual retirement age should be considered carefully. Look, we all know ourselves that sometimes if, let's say in companies, if the retirement age isn't until 66, the employee may still be fit and healthy and still want to work on just for an extra year. And any kind of request like that should really be considered carefully. If it's a case where you're happy to have that employee work on for the extra year, that's great. You can both come to a mutual agreement and set something in place. But it's just always important to ensure that that employee always feels like their work has been valued up to that point, and that any consideration for working on past that retirement age is carefully thought of and considered. But an employer can refuse a request, but they should consider whether they are good grounds to do so. So going back to the same point again, can the retirement age be objectively justified? So now we'll move on to dealing with an employee's request for longer working and what the procedure is around that. Now, first of all, employees should make a request in writing no longer than 3 months before the intended retirement date. And the employer should arrange a meeting with the employee to discuss the request, at which the employee is permitted to be presented by a colleague or a trade union representative. Then next, a decision should be made on objective grounds and communicated to the employee. And then if the decision is to offer a fixed term contract to the employee, this should be set out in writing with a clear indication of the relevant fixed term. So for example, if you've agreed that the employee will stay on for a fixed term contract of 6 months or 12 months, that should be set out in writing. Now, if the request is to be refused, the employer should set the reasons to the employee in a face-to-face meeting. And an appeal process should also be allowed, including an appeal meeting at which the same right to representation applies as the same as at the earlier meetings as well. Now, this does bring us to the questions and answers section. I know this is probably one of our shorter webinars before, but in relation to both topics, both probation and retirement, there is no real grey areas about it. I think it's very straightforward. You have your processes for both, and really when the process is followed for both procedures, they're is a way to avoid any potential claims to be brought up. We do have an awful lot of people logged on today, and I do see that there is some questions coming through. We mightn't get through to everybody's questions, but if anyone has any longer questions, things that maybe require a bit more in-depth detail, we would email you directly with those answers. So I'm just going to go to the very first question here, which is, how can one make retirement compulsory? Okay, so as I previously mentioned, in order to enforce compulsory retirement, the employer has to have an express, valid reasoning and justification behind it. That's the really important part, because compulsory retirement isn't exempt from being construed as discrimination, obviously based on age. So it is really important to make sure that you have a valid reason and have the justification behind it. Is there a minimum length of service for an automatically unfair dismissal or dismissal based on unlawful discrimination? So the simple answer here is no. Although a minimum of 2 years service is usually required for an employee to claim unfair dismissal, it kind of precludes, I suppose, the probation period from the probationary employee, from claiming that their dismissal was procedurally unfair or unreasonable. So there is no minimum length of service, so to speak. But as I previously mentioned throughout the webinar, when it comes to dismissing an employee during probation, as I mentioned, it's not that the employer can just decide at will, I want to dismiss that employee. They're the same as with retirement. There always has to be objective justification for everything. You need to have valid reasoning for everything, because it unfortunately is becoming a bit more common for claims to arise. I'm sure you all see it kind of yourselves when you look at articles and when you're on CIPD and things like that. There is still an awful lot of claims coming up in relation to unfair dismissal and retirement age. And that's why it's so important to make sure that when you're dealing with these kinds of conversations, that you have documentation of everything, and then you also have your justification behind your company decisions as well. So if I wish to dismiss someone due to poor performance, what steps should be taken? Okay, so if you decide to dismiss an employee for poor performance, or if it's misconduct issues that arise during their probationary period, and even if you may decide against following a full disciplinary and dismissal procedure, and you kind of go, I suppose, the informal route, and this would kind of include any right to appeal, really. You should always provide the employee with the opportunity to respond. So the employee should always have that opportunity to respond to any performance or conduct issues relating to their proposed dismissal. So you should always provide the employee with notification of your decision in writing, and clearly explain your reasons for doing so. And as I previously mentioned, retaining an accurate record. So make sure that you have an accurate written record of any disciplinary investigation that you've undertaken for an employee and what action has been taken in response. That's vitally important. And the employee should also be informed as soon as possible of the reasons for the dismissal, as well as the date on which the employment contract will end and the appropriate notice period related to that as well. How can I extend the probationary period? So firstly, you need to be careful not to extend the probation beyond the period of 12 months, as Saoirse mentioned. So after 12 months, the worker has the entitlement to avail of benefits under the Unfair Dismissals Act. Now, you can extend the probationary period if there's a provision to do so in your contract of employment or handbook. So everything in relation to probation, it does always come back to your handbook and your contracts as to what's in there. So for example, if you were to use our Bright Contract software, we have in there about the probationary period. We have everything in there about extending probationary periods, and you put in yourself as well the length of time that the probationary period is, and you include the probationary details. So things like that are so important to have in case something was to come up under the Unfair Dismissals Act, and you can say, well, actually, I have this detailed in my contract of employment or my staff handbook, and you're covered on that basis as well. But you should also hold probationary review meetings at set points throughout the probationary period to give feedback to the employee. So for example, if your probationary period is 6 months, usually common practice is you'd have a 3-month check-in with your employee, and then you'd have your 6-month check-in. So the 3-month check-in will be, I suppose, kind of like a progress check-in. Where you, as the line manager, you'd consult with them about how they have found their role so far, any difficulties they're finding, and then it gives you the opportunity as their manager to bring up any areas that they need for improvement. Because these things cannot be brought up after the 6 months and then used to terminate their employment, because they haven't been given the fair opportunity to improve their performance. And that's the main thing as well that you want for your employees, that when they come into your business, you don't want to set them up for failure. You want them to get better at their role. You want them to contribute well to your business. So they can only do that if they know, okay, I'm a bit weak in this area, I need to improve on this, I need to improve on that to get to the next point in my career. So consistent feedback is vitally important. And the final probationary review meeting, this is where you'd assess the employee's performance and suitability to the role as a whole. And from there is where you'll either confirm the appointment, so whether they'll become a permanent employee, if you're going to extend the employee's probationary period generally by a further 3 months, or if you're going to dismiss the employee. And when it comes to dismissal, as I previously mentioned, documentation is vitally important there, because while a claim for unfair dismissal may not come up in the 3 months preceding the person being dismissed, it could come up in the 6 months after that or a year after that. You just don't know when something could come to fruition about that dismissal. So records about performance and any conversations around performance are so vitally important. Okay, so that seems to be all the questions that we have there now today. I know for some people, we have gotten a few queries into the Bright Contracts line around probation, which have been a bit more kind of complicated, I suppose, situations. Now, obviously, we aren't insured to give HR advice, and we do typically just give advice in relation to what we know about the topics. But if there is anything that any of you who have attended today would like to discuss in relation to probation or retirement, please just either send us an email or give us a call. Thank you very much for attending today. I hope that you found this content useful and that you feel a bit more confident in going forward with your probation and retirement conversations. As I previously mentioned, in the follow-up email, there will be a recording of today's webinar as well as a PDF of the slides, but I will also be including a document where I have kind of put together, I suppose, like the probationary steps in relation to probationary review. So I'm also going to include that for you all as well today to give you a bit more guidance in relation to how to have that conversation and follow that process. So I hope you'll find those useful as well. In the follow-up poll as well at the end, if you aren't already a Bright Contracts customer and would like to sign up for a demo, please just register your interest. If you'd also like to sign up for our newsletters, please let us know as well. But thank you again for attending, and we hope to see you all again at our future webinars. Have a great day. Thank you so much.